I think most of you have my email. And if you do have any questions, just send them to me. And what I'll do is I'll just put in the chat window for you to see that my email address so that you can send me any emails you want. I'll try and answer questions as we go along and or at the end. In terms of the time today, I'm conscious we start a little bit late. I'll still try and finish by 2 o'clock. And I think the reality of it is you should all have had a handout anyway, which is very detailed, and I won't repeat much of the material there. So in your own time, feel free to sit down and digest that in more detail. So let's make a start. So what we're going to cover today is, of course, representing parents with learning difficulties in care proceedings. And as I say, I hope you have the handout. Use the handout to guide you as we go along, because that's my sort of tool through this, rather than necessarily focusing on the PowerPoint itself. I think it's more helpful if you look at the handout. So what we'll learn is we're going to explore the kinds of limitations that parents with learning difficulties can face. We're going to look what the law says about how such carers should be properly supported. We're going to look at what is actually done on the ground and whether that correlates by what should be done. And we're going to look at how to challenge what is being done on the ground to make sure that it matches what legally those parents, those potential carers are entitled to receive. Let's start at the first point, which is what is typically done in care proceedings. Now, I think it's right to say, before we turn to that, that in fact, we need to know as a collective what the kind of limitations can be on parents with learning difficulties and disabilities. Around 2.16% of people in England have a learning disability, and there's even more people that have that when we add in learning difficulties into the mix. So it's more common, sadly, than we like to think, and certainly in care proceedings, we see it a lot more. Remember that the disability and or the learning difficulty doesn't always have to be visible. We can have impairment that is entirely something we wouldn't necessarily know about. It's about the way it affects how that person thinks, how they will learn new things, how they will process it. And it's entirely different for everyone. So because we've worked with one parent with a learning difficulty doesn't necessarily mean we will be able to spot it in someone else. Remember that it can affect the way that they compile information and understand it. It can affect the way they learn new things, and it can also affect the way that they look after themselves. Be alive to the fact that the person themselves might not know that they have this difficulty. Or they may not realize that in fact the things that you're explaining to them are not things that they are able to properly take in. So the serious nature of some of the information you might be giving them. Be alive to the fact also that they might be ashamed of speaking up about it, because there's a lot of stigma still attached to having learning difficulties and disabilities. And so they may themselves pretend to understand things when in fact they don't. And remember also another limb to it, another complication, is that, excuse me, the learning difficulty or disability can often come hand in hand with other more physical issues. So for instance, we have what the NHS calls a profound and multiple learning disability, which means that they have sight problems, hearing problems, speaking problems, or moving problems, all compounding the learning disability and or difficulty that they may have. And the result of that is that they may have specific health and social care needs, and we will come back to that in the slide later, because it may open a door for them to be able to access further support that we don't normally talk about in care proceedings. So all of that are factors that you need to be aware of when you approach this, and we must always approach this with a relatively open mind. With that in mind, understanding the kind of carers and parents we can work with, we can now turn to what is normally done in care proceedings. I think it's fair to say, and everyone will agree with me, that the typical what's done is wheeling out the old PAMS assessment and going, well, parents have got learning difficulties or disabilities, let's do a PAMS assessment of them. Whether or not we actually know in detail about what a PAMS assessment is another matter. A lot of you may know about this, and some of you may know very little, apart from being told it's what you do. But let's talk about that in some more detail, because the PAMS assessment was a tool identified and developed in 1998 by Dr. Sue McGraw. She is a clinical psychologist.
If you've booked onto it, I'll send the link. to...
Okay. She was a clinical psychologist who developed a tool that was really there to assist parents with learning difficulties and disabilities. And very much the intention was to support them. But of course, this is something from 1998. And whilst I can still remember 1998 because I'm so old now, the reality is technology, if nothing else, has moved on a lot. Ways of thinking have moved on and technology has moved on. And we'll come back to that because, in fact, one has to think about when one looks at the flaws of a PAMS assessment, how does it consider, for instance, the ways that parents can access support these days? So, for instance, I had a case with a mother with a very severe learning disability, but despite that, she was able to make TikTok videos, she could Google things very quickly, she could access the internet to look up anything she needed relatively easily. And that was a tool that she had used so much in her life, repeated so much in her life, that using her phone was pretty second nature. When the PAMS assessment came in, it made no mention of, and it had clearly not taken into account, the fact that if this mother gets stuck in terms of caring for a child, she's relatively able and actually would look up on the internet what to do next and follow guidance therein. Things like PAMS assessments can exclude that because, of course, it wasn't designed to consider things like how easily accessible information is to us now as an online tool, and the fact that most people with learning difficulties and or disabilities can still use mobile phones these days and find ways to access social media and to Google things and understand, or to do things like create WhatsApp groups with friends who they can ask for advice, or to do things like do regular video calls for people to check in. These are all things these people are now able to access more and more so. Not everyone, but a lot of people with learning difficulties and disabilities. And the PAMS assessment might hinder them because of the fact that it was created so long ago, it doesn't quite fully accept and understand all of that. In terms of the structure of the PAMS assessment, and again, I'm going from the handout, I've given you lots of information about PAMS assessments, so I'm highlighting the bits I want to talk about in this seminar. What we will all know, or anyone who has worked on a case where a PAMS assessment has been filed, is that what it does is it goes through specific parenting criteria, and then it tries its best to make a conclusion on if the parent is able to meet that particular need, and if not, what teaching they may need and how serious and or urgent that teaching may be required. But you see, one of the obvious difficulties with that is, of course, when the parents will get the PAMS assessment, they might not understand it. In fact, they're very unlikely to understand it. We know when we've read PAMS assessment, it's taken just about every brain cell I have sometimes to unpick what's being said in a PAMS assessment, because it's written in a really complex way with lots of tables and graphs. And if you're giving that to a parent with a learning difficulty or disability and saying to them, look at what's being said about you in the, as they call it, domains and teaching recommendations, you need to work on X, Y, Z. That's really hard for them to understand and put together, particularly, for instance, if it's done pre-birth and so they don't necessarily have lawyers, or the lawyers are only coming on board a short time before proceedings are issued. It's very difficult to unpick what the difficulties are for them to make improvements in a good period of time when the information is in such an inaccessible format. Another issue that I have with PAMS assessments is, of course, that a lot of it normally happens because you have to be trained to deliver it. Not all social workers are trained. So a lot of it, if not all of the assessment, is normally delivered by a worker who is brought in to do a PAMS assessment. The thing about working with parents with learning difficulties and disabilities is that it can, how do I put this? They perform best when they are in a comfortable setting and can feel relaxed and are less likely to make mistakes or be hit by anxiety or feel stupid. And that happens when they are with someone they trust, someone they've built a relationship with. Believe it or not, sometimes the best person to do an assessment of these parents is the social worker on the ground, just because they have built a relationship with that parent, which means that that parent won't feel incredibly nervous around them. When you have a new PAMS worker coming in, sometimes what happens is the parents feel on edge. It's a brand new person to learn, to work with, to build a relationship with. What you can have is that person observing limited sessions and limited teaching to form an opinion on these parents, and much of their opinion will be informed by, say, the views of the social worker or other professionals who have observed the parents, rather than direct observations themselves over a prolonged period of time. The other disadvantage of that is, of course, when the teaching recommendations are formed in PAMS assessments, you have to look at, well, the worker will look at, the teaching's been done, have they learned enough? No, and tick that box. In fact, if the worker is the one who delivers the training and the teaching, they can better understand, can't they, how that parent develops, at what pace they are moving in their learning, and whether any adaptations are required. So again, there is difficulties with multiple workers coming into work with parents because of how bespoke a PAMS assessment is, that may lean away from it being delivered by an ISW, for instance, or someone else in the authority, and may move more in favour of this being done by the allocated social worker or another professional who knows the parents well. So those are some of the issues that I have with PAMS assessments. And I think we must reflect on them because they have advantages to them, but they are not the panacea that perhaps we look at them as when it comes to care proceedings to go, this is how it should be done. Remember that a PAMS assessment, when created by Dr. McGrath, was created to look at issues of basic care only. So when you have these cases that often involve multiple issues, domestic abuse, mental health issues, substance misuse occasionally, PAMS assessments were never designed to assess the risks in that context. They were designed to assess the risks that can be posed and the teaching that would be required for parents with learning difficulties. So they are limited in what they can do in terms of analysis and risk planning around those issues. I tend to find PAMS assessments also lack a proper analysis of the wider support that can be put in place, whether that be family, social media, for instance, as I've said, WhatsApp groups, the ability to Google and find answers these days. PAMS assessments don't seem to be able to fully grapple with the family group conferencing stroke support building that one needs to consider in these types of cases. And finally, I think it's right to flag that PAMS assessments were designed to be completed with the child in the parent's care. Now, many of us who work with parents with learning difficulties and disabilities will know that often in these cases, what these people require is repetition and high levels of repetition to allow them to embed their learning so that they can improve in the parenting that they can deliver. PAMS assessments don't really allow that if in fact the child isn't in their care. The way the assessment was designed was to allow the parent to have the child so that they can learn and grow. And the PAMS assessment doesn't actually do that 9 times out of 10 in the way we use it, because chances are the child isn't in their care. Chances are the parents are given a limited amount of contact every week and they don't get that opportunity to learn. You see, pausing here, if you're for a parent at the first hearing, what I often do is raise this issue because, one, it may gravitate towards the need for a residential assessment because of the need for repetition and embedding, and or two, it may gravitate towards higher levels of contact for the parents by flagging that this need for embedding and repetition is required and that a parent with learning difficulty requires that even more so than other parents in these proceedings. So those are the kind of issues that I think we need to be alive to and recognise that while PAMS assessments have benefits, there are these issues with them that we have to be alive to. And my advice to you is if you have an authority saying we're going to do a PAMS assessment, well, I would want to know multiple things from them. One, I would want an assessment plan to see what will be done. Two, I will want to see the teaching work and the recommendations from where they got those from. For instance, normally they do a PAMS pre-birth and then do an addendum. I'd want to see how those recommendations will be implemented and who will do the teaching and whether it can be the same worker. And I would also want to see how much time my clients are being given to learn about that, whether that be time during the proceedings and or extra contact sessions to allow them to embed what they learn. So all of that is appropriate. I think PAMS has a place, but one has to think about bearing in mind the gaps and the difficulties that can come with PAMS assessments. We, as a representative parents, sometimes need to make sure that we flag those issues very early on and get them addressed before the assessment starts to avoid difficulties. One of the issues that I find in care proceedings that really upsets me, and I'm sure upsets many of you, is sometimes you get to the final hearing, and by that point, when you look at the case, there's lots of, we could have done this differently, we could have done that differently, but in many ways the nail is in the coffin for the parent at that point, and it's too late because people turn around to say, and the court turns around to say, well, we don't have the time to redo it, delay isn't right for the child, we need to make decisions now. And as the advocate or the practitioner on the ground who can see that actually maybe if things were done a little bit differently, we might have been somewhere different, it can be hurtful to see those kinds of cases. My advice to you is to try to grapple with it early, preempt what might be needed, preempt the kind of issues that parents with learning difficulties can face when, for instance, they are offered PAMS assessments, and make sure the local authority plugs the gaps around these issues early on to give those parents the best opportunity that they can have. We've discussed there some of the benefits, some of the disadvantages. I've written there views of parents about the process. Now, this is more subjective, this part, but this is what I have come across in my experience. When I have represented parents with learning difficulties, these are the kind of things that they have said, and I think it's important that we reflect on that. One of the things that I had a parent say to me was, she's showing me lots of pictures and asking me about them. I don't get what she meant. And I think that's quite telling, because one of the parts of the PROMS process is that it is very formulaic. It's very set and rigid in what it involves. And it does involve, for instance, pictures and saying, what are the risks in this picture? What would you do different in these pictures? And for a lot of parents, that's useful. But there are parents who struggle with that in terms of seeing it in a picture versus being able to do it in real life. I remember I had a parent say to me, and again, it's from a list of things I want to read to you. She's asking me questions when I have my baby to look after. It's confusing. I can't focus. So that's multiple things going on at once for them as a result of the PAMS formulaic structure. That doesn't work. She's teaching me something, and then I don't see my baby for a week, so I forget it. So that's the point I make about repetition and making sure that they have good enough contact to embed their learning. How can, and this is another one, which is, she's asking me how I would do things, but I'm better at showing her what I mean. So this is particularly important to the point I make about parents who, the system being designed, or the PAMS assessment being designed to allow these parents to care for the child whilst the PAMS assessment is being done. Typically, we see PAMS wheeled out, for instance, for pre-birth assessments. And whilst they have a use in that way, the downside of it is that a lot of parents with learning difficulties are better at showing what they can do than talking about it. And the problem with that is, if they then can't demonstrate it because they don't have a child in their care, the PAMS assessment will likely say, well, there's a gap there, when in fact there might not be. And so it's all these difficulties that you need to be alive of, because whilst it has positives, there are disadvantages, and many parents who go through it don't necessarily find the system a useful one. Let's talk very briefly about the alternatives to PAMS. I'm sure some of you have heard of the Parent Assess framework, which was established in 2016. So it's a much more updated, modern assessment for parents. In many ways, it uses a lot of the tools of the PAMS assessment, but they have adjusted it, I suppose, to meet the times and to reflect some of the critiques that have come as a result of the PAMS system. So, for instance, the one thing I like about the Parent Assess framework is that the assessments are written up in a way, and actually are written up along the way in terms of interim reports, in a way that's very parent-friendly, for them to read and understand what the issue is and what they now need to do to remedy that situation. There is a traffic light system that means that things are easy for parents to understand. So, for instance, red is obviously you need to work on that and it's a big deal. Amber is we need to do some more teaching on it, and green is you're okay on that one. And parents with learning difficulties and or disabilities can find that a lot more relatable to, and it's better feedback for them on the ground to know what they need to work on. As lawyers, we wish we could support these parents every step of the way. And to be fair, I suspect social workers wish that they could do that as well. But the reality is we can't be there every day when this parent will be in contact. We can't be there every time someone will give them feedback. And that is why it is even it is all the more important that what they will receive in writing is more parent friendly and understandable for them to be able to reflect on what needs to improve and actually change it. It's very little use to us when we get the PAMS assessment. We as the lawyer, it takes us about a day to decipher what the frigging thing's saying because it's so complicated, and then we try and feed it back to the parent. But of course, by that point, by the time we've got the assessment, it's too late and things have gone wrong in many ways. So yes, so it has those advantages in terms of how it's delivered, and I've put the link about it for you to read more on the seminar if you wish to consider it. We have things like residential assessments, which again, I'm not going to teach you how to suck eggs, you'll all know about, but of course it's worth flagging that I see one obvious benefit from a residential assessment, which is the point I make about the ability to embed the learning and the growth and the development through repetition. You don't get that in any other better setting than a residential assessment. But of course, it's a double-edged sword, because the other thing about a residential assessment is they're being watched 24/7. And so every little thing that goes wrong will be monitored and recorded. I suppose another downside that makes me very cautious about using residential assessments is that we often get parents saying they are very isolating. They normally get sent away to somewhere very far away from family and friends and their network. They find it hard to adapt to this new environment, particularly if they have learning difficulties. And they then can find that they can't manage to stay there for the full period. The placement breaks down, and that makes the situation all the worse. It's worth balancing, therefore, when you find out that you have a case with parents with learning difficulty, whether in fact that placement is one might be suitable for them, or whether you might want to go down a more bespoke assessment like Parent Assess or PAMS, simply because you don't want to set them up to fail. Of course, an independent social worker has a role to play, and I would say we all know, don't we? We get some really good independent social workers and we get some who are not so good. If you have an independent social worker that you know will do a fantastic job with parents with learning difficulties and have in the past done their best to do a fantastic job, by all means go for it, because we know that independent social workers can be the make or break on a case in terms of what the conclusion is. They can offer a wealth of knowledge. They can also be that independent mind from the authority to think more widely about what support can be available and to pressure the authority into making sure that it explores all avenues. So yes, that's an option, absolutely an option. And finally, think about, as I said earlier, bespoke social worker assessment, even from the worker on the ground. If they get on well with the parents, and if the parents feel that they can get on with them and work with them, that may be the better option for these parents. So what do we look out for then? Now that we've gone through the type of assessments and what is typically done in care proceedings, remember what I said about assessment plans. Always get them. See what the issues are. See how they're going to plug it. See how the teaching is going to be delivered. See who's going to be delivered and to deliver it and how trained are they. Look at the contact levels. Run the argument that these parents need repetition. Get them the extra contact. 9 times out of 10, you'll get more contact for that argument, in my experience, than you would without running it. Scrutinise the assessment to be done and all of the difficulties we've discussed to make sure it's properly dealt with. Look at the issue of wider support early. Now, I will come back to this. I've got a lot of slides on this, but in summary, one of the big things that comes out of the higher courts is that parents with learning difficulties often need support, and they can need support not just in the short term, but in the long term, sometimes throughout the child's minority. Local authorities typically do the whole, oh, well, we can offer this under a care order, and we can offer this under supervision order, and we can do this under SIN. And they don't think often, not always, I'm being critical of authorities, but often, outside of the box. You have to, as the advocate, ask earlier, I believe, about the issue of support. Ask them to do family group conferences. Ask them to consider things like what nursery could provide, what family support workers could provide, what teaching and recommendations could be delivered on an ongoing basis. Ask them to consider things like, if your client, the vulnerable parent, is a care leaver themselves, are they entitled to care leaver support? How would that fit into the picture? Now, I will discuss that more shortly because I have a lot of slides on it, but I hope that gives you an introduction to what I mean when I say think about the issue of support. Think about it early so that the authority can start to look at it from the very beginning of the case before it's too late. 26 weeks. Well, do we need more time? I will come back again to this point, but I want to flag this here for this reason. Often, and especially with the push from the above, we are now being told things need to be done in 26 weeks. And often the judges are saying things need to be done in 26 weeks. Be brave. Don't let your client with learning difficulties and/or disabilities have their opportunity for learning and teaching squeezed into a rigid time frame. Don't ask, don't get is my approach to cases. Anyone who knows me knows that. And I think with parents with learning difficulties and disabilities, you must ask for further time for them to embed and learn their teaching, for that to be delivered in a way that they can reflect on it over time rather than squeezing it all in because of a tight timetable. Bear that in mind. And as I said, it says, does the assessor have the relevant assessments? By that I mean, does the assessor have, for instance, the cognitive assessments? Of course, when you have parents with learning difficulties and disabilities, I would always urge to get cognitive assessments. Sometimes you might even need capacity assessments. But at the very least, get a cognitive assessment, learn what these parents require, and make sure that the people who will deliver the teaching and the person who will assess have those assessments and understand those recommendations. Again, these are all things to tackle at the case management hearing before we get the ball rolling on the assessments, to make sure that your parent gets the best chance they can to succeed later on in these proceedings. So what does the law say then? We've talked about what's typically done on the ground. Let's look at what the law says when it comes to working with parents with learning difficulties and disabilities. One of the cases I wanted to flag goes all the way back to why in the United Kingdom, because I believe it sets the tone about what we should be doing. You see, just bear with me a moment. I'm just trying to find my notes to make sure that we cover it right. So the thing about why is it isn't a case about learning difficulty specifically. It's a case about the proportionality of a plan of adoption for a child. There were lots of positives about the parents at the time. For instance, clean home, some basic care issue was well looked after, but there were issues around substances and the father's aggression and domestic abuse. And the case really went up about the issue of an Article 8 right, and whether in fact that could be impinged on the way proposed by the local authority, i.e. through a plan of adoption. The higher courts at the time, the European Court, considered this. Family ties may only be severed in exceptional circumstances. This is the bit I wish to flag to you. Everything must be done to preserve personal relations, and where appropriate, to rebuild the family. It is not enough to show that a child can be placed in a more beneficial environment for his upbringing. Now, I think this case is really important because, as I say, it set the tone for what then became quite a lot of case law on the issue of working with parents with learning difficulties. Remember the sentence, right? It's not enough to show that a child can be placed in a more beneficial environment for the upbringing, and everything must be done to preserve personal relations. So how does that then apply to what the courts have said about parents with learning difficulties in care proceedings and how they should be supported? Well, let's look first at Re-A. Re-A, the Court of Appeal had ordered a retrial due to concerns that a father with learning difficulties had not had a fair trial regarding findings that he'd inflicted injury on his child. At the retrial, Mr. Justice Baker gave some advice on how to conduct proceedings where a party is vulnerable due to a learning disability. And I would say it applies equally to a person who has a learning difficulty. And I wanted to flag some of that to you because, as I say, it's on your handout. Do look at it in your own time. He gave advice as follows. There's a duty on those acting for the parents to identify their clients' needs early on. Which comes back to what we said and made sure all of this is set up at the case management hearing. To him, to Mr. Justice Baker, the duty on the lawyer means identifying what type of assessments may be needed. For instance, cognitive assessment, PAMS assessment, parenting assess, intermediary assessment, whatever it may be, capacity assessment. We need to flag that and identify it early. But it doesn't just fall to us. In fact, if the local authority knows that a parent may have a learning difficulty and/or disability, there is a duty on them to flag it in the application so everyone can know. And there is a duty on them to adapt their approach to that parent to make sure that they are properly and fairly supported through the process. Remember that the court should hear these applications at the case management hearing. And remember that, of course, as I said to you before, when the assessments will then be underway, All issues should be tackled, including how to adapt to that parent, how to make sure they receive appropriate teaching, and exploring the support that they can be provided with to ensure that they can get their best chances of caring for their child. Let's look at RED, which is the next one. Swindon Borough Council, they are named in the judgment, and that's how I know it was them. So that perhaps tells you what can happen when authorities don't quite follow the guidance. They can get named when it comes to these types of cases. Sought a placement order for a little boy over placement with his parents. You see, it was an interesting case because the parents, well, the mother had a learning disability and the father's difficulties were so bad that he lacked capacity. And in essence, they'd come into care proceedings, they'd done an assessment, and the little boy had gone back home under a care order. This was after a residential assessment. The local authority then sought removal under the care order that they had later on outside of proceedings, and sought a placement order to place the child for adoption. Sadly, the court did grant that order. After an ISW had assessed the parents and decided, no, actually, I don't think they can do this. But whilst the court had granted the order and placed this child for adoption, Swindon Borough Council were heavily criticised. And they were criticised, and ultimately an ISW, as I say, was appointed to assess over them for their lack of support that they had given to these parents and for not properly adapting the approach that had been taken to the parents with learning difficulties. Mumby, as he then was the president, had to set out some guidance on how to approach these types of cases with parents who have learning difficulties. He endorsed what I said to you earlier from Why in the United Kingdom. It is not enough to show that a child could be placed in a more beneficial environment. He reiterated what we know and have all heard time and time over: society must tolerate diverse standards of parenting. And he also endorsed, interestingly enough, some comments made in another judgment. I say comments, law made in another judgment, one of Gillian J in a Northern Irish case where she had sat in the High Court in Northern Ireland, the Reagan A care order case, and had given guidance about how to work with parents with learning difficulties and disabilities. And Mumby said, actually, this is really good and we should be following this guidance in England, and so it's become our law as well. In essence, what happened is Gillian J set out 8 paragraphs of principles that should be abided by, and they've stood to the test of time to now, that I would always encourage anyone representing parents or social workers working with families with learning difficulties, or even solicitors working within the authority and wondering how do we safeguard the authority from criticism, it is to read this case and to read the points that Gillian J made and Mumby endorsed. I won't go through all of them with you. As I say, it's in the handout, but there are a few I want to highlight. People with learning disabilities are individuals first and foremost, and each has a right to be treated as an equal citizen. Courts must take all steps possible to ensure that people with learning disabilities are able to participate. When it says courts should take all steps, it does actually mean not just courts, of course. It means the local authority, those assessing. Parents with learning difficulties can often be good enough parents. Remember, that is the standard we're going for, good enough. And that the concept of parenting with support must underpin the way that the court and professionals approach these cases. Now, pausing here, the tone that comes through a lot of this case law is, of course, one that there is stigma attached to parents with learning difficulties, that we can often write them off because we don't fully appreciate that, in fact, they could care to a good enough standard, or that because we sometimes, whether or not we mean to, can view the situation as one where the child may do better elsewhere, and we should guard against that in our thinking. We often see in these types of cases a comment thrown around. It's called substituted parenting. And social workers and guardians will often say parents with learning difficulties can't care because it would amount to substituted parenting. Now, Mumby and Gillian J both raise this point of parenting with support, and it is contrasted in the case law, the difference between parenting with support versus substituted parenting. Substituted parenting is 24/7. But often what professionals can end up doing is inflating the two, looking at parenting with support and not realizing that what they're describing as substituted parenting is in fact parenting with support. Parenting with support can mean long-term parenting support. It can mean the child being under a care order until they're 18. It can mean lots of professionals being in and out of the child's life. It can mean that these parents require ongoing training and learning and teaching to meet the children's needs. And often professionals can turn around and go, well, that's too much. The stigma of lack, this professional intervention, it's too high. These parents can't do it. And actually think that what they're referring to is substituted parenting. The case law is very clear. Long-term support for parents with learning difficulties and long-term involvement of professionals is absolutely fine in these types of cases. And in fact, it needs to be explored as a way to keep children in the family. Because if a parent can care with high levels of support, then that child should remain with them, particularly if with those high levels of support, they could then meet the good enough standard. Even if it has to be done, the support has to be given on a long-term basis. There is, of course, a line that has to be drawn, and there is a point where it becomes substituted parenting. But how does one draw that line? How does one know what parenting with support versus substituted parenting is? That is the balance that the judges often should be striking, and often will have to strike. If I was representing a parent with learning difficulties, or if I was for the local authority in a case where I knew that argument was a real one, I would be doing this. I would be asking the social worker to very clearly set out in a statement or in her final statement or in the assessment exactly what support can be provided on the ground for this family, for these parents and for these children. And then I would have to make sure that there is an analysis from her as to why that would not be enough to plug the gap. That is how social workers and assessors get around this, by highlighting very clearly why they say it reaches the threshold of substituted parenting and is not parenting with support. On the other side of that coin, if I'm for a parent, I would always ask the social worker to spell out in a statement what support can be provided, because I will be arguing at the final hearing that that is not substituted parenting. With this level of support, it absolutely falls into the criteria of parenting with support. And so that is an interesting concept that came out in Reedy, and it was an interesting concept that Gillian Jay raised in her judgment as well. I think there's lots coming out in Reedy. Please read it in your own time, but those are certainly the points that I wish to highlight for you at this stage around parenting with support. And look, I've covered it already, haven't I? So we'll move on in the slide. Now, something else that I wish to talk about is the good practice guidance on working with parents with a learning disability. And just bear with me a moment, because I want to take this in turn. Sorry, I'm just looking up the laptop because it's just said the battery is running low. Lee, if you're upstairs and can hear this, can you just nip down and just double check that this is plugged in? Because I just don't want this laptop to die, please. We'll see if he runs down in 5 minutes. So, good practice guidance on working with parents with a learning disability. In a case of A local authority in G in 2017, it highlighted the importance of all families that the importance that all families in which one or more of his parents have a learning disability are given the support they require. So it's the point we come back to about making sure everyone is properly supported. And what it really did, which I found really interesting, and I think we should take away, is highlight this very guidance, the good practice guidance on working with parents with a learning disability. Because this was guidance that came out in 2016, and it is ultimately guidance for social workers. It sets out in a lot of detail what social workers and assessors and people working with these parents with learning difficulties and disabilities should be doing in care cases, and when assessing them, to make sure that the style is adapted, to make sure that they are properly supported, to make sure they're giving every opportunity to grow and develop in a way that would allow them to be able to provide good enough care. It is the Bible when cross-examining, because I can assure you that if the assessor doesn't know what the good practice guidance on working with parents with a learning disability is, then chances are they've done it wrong. I would absolutely encourage solicitors to read it, anyone listening to this seminar to read it. Social workers need to be aware of it and adapt it to their assessment plans and their assessments. And workers doing teaching work with parents need to be aware of it. And solicitors working for parents need to be aware of it, because, as I say, it is your tool to cross-examine. Has it been implemented? If it hasn't been implemented, your client has almost certainly not had a fair assessment. The courts, the higher courts have always been critical of, or are critical of local authorities and assessors who do not follow this guidance, and have specifically said in case law they didn't know about it, and that's a huge problem. So please be aware of it. And what it says then, I'm not going to tell you completely what it says, because of course a lot of it's in the handouts and you can read it, but it says services need to enable children to live with parents. If the problem is seen as entirely related to impairment and personal limitations, it is difficult to understand how to bring about positive changes for parents and their children. If the focus is instead on things that can be changed, such as inadequate housing and support needs that can be met, there are many possibilities about bringing about positive improvements. It's about shifting the way that social workers might think of parents with learning difficulties. Remember that social care should provide, according to the guidance, accessible information and communication, clear and coordinated referral and assessment procedures and processes. Pausing there. One of the big issues that come up in this case is that when we look at what support parents can have, they won't just get support because the child will be under a care order. Often parents with learning difficulties and disabilities are entitled to support from adult services. If you are for a parent, you want to advise them to accept that support, because quite often I see these parents going, well, I don't need support, and rejecting adult services support. They need to use that support because it is another limb of support that you can rely on to say this child may be safely kept with them, because adult services offer this, this, and this in addition to what children's services are offering. For instance, they can get an advocate through that. They can get someone to help them with budgeting through that. They can get someone to help them with benefits and claims through that. They can get a certain allowance, sometimes financial assistance through that, all of which will assist them. The local authority, from the good practice guidance, should be making sure that clear and coordinated referrals and assessment procedures are in place, which will include making sure that when these parents are seeking to care for their child, they are given appropriate referrals to adult services. There is joined up thinking between adult and children's services, and any support package that is pulled together at the end and or considered by the local authority and ruled out should address the support that adult services could have provided to make this a viable option. Adult services may also have things like accessible information and communication. So every authority has handouts for parents with learning difficulties and disabilities. Simple information on how to make a bottle, how to make a bed, how to do this, how to do that. Normally, adult services either have that information or know where to get it easily. And the amount of times I cross-examine social workers and go, when they say, Mum can't make a bottle, and I go, have you got a handout in the authority on how to do that? Yes. Have you given her that? No. And it's such a basic thing. So again, you need to be flagging that and asking them to speak and liaise with adult services, to set out in a statement from adult services, what support can you offer? Because that sometimes can be quite a lot more than we would think. It talks about support designed to meet the needs of the parents and the children, long-term support where necessary. And remember that parents in these situations, it's a daunting process, and having advocacy, access to advocacy and an advocate to speak for them is also in the guidance. They should be given that. Remember the joined up thinking between adult and children's services, health and social care, because again, support can come from lots of avenues, and we'll come to that again in a moment. So I won't cover all of this. It's useful. It's really useful to know what is being said about how these social workers should work with these parents, what they should look at for support, clear communication, making sure parents understand role play, modelling, videoing parent and professional undertaking a task together, step-by-step pictures, repeating topics regularly, offering opportunities for frequent practice. All of this is useful, and make sure that if you cross-examine, you use it, and if you're planning for the local authority to make sure they deliver a fair assessment, use it. Finally, remember that the Equality Act 2010 does impose a duty on local authorities to make reasonable adjustments when parents have a learning disability, and so local authorities could actually be liable to discrimination claims if they don't do that. Okay, so let's move on a little bit on the case law. I'm conscious of the time, so I'm trying to get through quite a bit, which is my own fault, because anyone who knows me, and I think lots of you know me, know that I can talk for England, which doesn't help the situation, does it? So A, local authority, and G. Now this case highlights really the failures when good practice is not adhered to, and shows that good practice for professionals working with parents with learning difficulties does involve local authorities reviewing their own practices and procedures. What this case said should happen is this. It provides good practice for professionals working with parents. There should be a system of referrals and assessments, as we discussed. There should be very clear guidance on who is assessing and who isn't assessing, and what support can come from where. They should be the adult services team and the social children's services team should be working together. They should be training for those working with the family so that they can understand the difficulties that those parents may have and can adapt. For instance, give them the cognitive assessment. The parents should have independent advocacy, and everything should be timely and appropriately tailored. So one of the other issues I always have in these cases is a local authority will say, oh, they need teaching around X, Y, Z, and then take 4 months to get the teaching program running. By which point, if the parents were bad before, they're far worse now because they've not seen that issue dealt with. They've not had repetition. They've not had anything to help them and support them with it for 4 months at this point. And again, timely and appropriately tailored support is what's needed. Promptly identify and implement both in and out of house support services, use appropriate assessment materials, so that the kind of handouts and things I've talked about, provide clear communication, checking with the parents what's being said. For the reason we come back to, they may be embarrassed. Use role-play, modelling and other suitable methods, such as videoing and professional undertaking a task for discussion. That's really useful. Not many local authorities do it, but videoing, say, the professional doing it and the parent then having that little video can be incredibly useful. So it's worth, I think, just making sure that that is all in place. Oh, I've just had an email to say the sound isn't working on the webinar. Can you all hear me okay? If Lee can hear me, I'll just ask him to drop me an email. I'm just slightly worried about that. Or if someone can just drop me an email to say if the sound is working and you can all still hear me okay.
It is working, it's recording.
Okay, thank you, that's helpful. I don't know if it's you, Paul, you might need to come out and come back in, sorry about that. Repeat information and topics, offer opportunities for frequent practice in the home, provide the use of props to assist with undertaking care tasks, and if long-term support is required, identify it. Get in the process of actually figuring out what's needed and how to get it accessed. Nottinghamshire Council then, this was a case, and again you'll notice what I'm doing is I'm taking this, I started in 2012 and we've been working our way through to understand how the courts have viewed this. And I hope that that will assist you all to see that the move from 2012 to now is very much pro support for these parents, making sure that they get what they need. And so I hope that that assists you all. Thank you. You've all emailed me. I've had 300 emails going. We can hear you. Thank you very much, guys. I appreciate that. Looks like I'm the one getting support today. Thank you. And so we're now up to 2022, and we've worked through the case law from 2012 to now. The 2016 guidance still remains relevant, by the way. It's being repeated in this case law. So in 2022, it is clear to me that learning about the good practice guidance on working with parents with a learning disability, first published in 2007 and then amended in 2016, and then again in 2021, should be widely disseminated to both children and family workers and adult social care workers. So in 2022, they're saying this guidance is still relevant. And if your social workers don't know about it, if your assessors haven't implemented it, there's big trouble here. That's what the court is saying. I think that's really important because it shows that what I'm saying to you isn't just something that has passed on the wayside. It is still really relevant, to the point where even in 2022, parents with learning difficulties involved with children's social care where a child is on a child protection plan should have their own advocate. A referral should be made. Support available to them should be given in their own right. Put the information in a simple document identifying what is available, how often it's available, the timescales for its availability, who is responsible for its delivery. Pending assessments should be noted and followed up on a regular basis. Documents should be shared with children's services, discussed with the parent in the presence of their advocate. Support with the care of a child which is available and which is being delivered should also be distilled into a simple document. So lots of the same tone and approach of offering this support in clear ways, making sure things are prompt. Lots of it is still coming through from the guidance 2016, amended in 21, still relevant in 22. And then we had the case in 2023 of Re-H. It's a long history to this case, so I won't give you all of it in detail. Suffice it to say that there were issues with a newborn baby on a background of a series of risks to older children in the family. The judge did do as the local authority asked. The Court of Appeal, however, decided otherwise, and decided that whilst the judge in that case had had been told about the case law, had cited the case law in their judgment to say things like, we need to look at parenting with support. We need to make sure parents have had everything. The reality is he had then not applied it in the judgment. That's what the Court of Appeal said. And what the Court of Appeal said is, you need to be careful of this issue of substituted parenting. The judge did not adequately scrutinise the evidence about the support needed. It's the point I come back to. Parenting with support is often what it is, and they will be called substituted parenting. Professionals who do that need to be scrutinised very carefully around what support can be available realistically, and why that couldn't plug the gap. And often what instead we see is a social worker or a guardian or a professional doing the assessment and saying this is substituted parenting, without identifying first, well, what support is available? Why is it substituted parenting? The starting point should have been to identify and describe the level of support needed. Secondly, ascertain what can and should be doing or done under the local authority's obligations, and thirdly, determine whether with that in place a child's welfare will be met. We don't often see that, sadly, in the analyses that we see in these cases. We don't see it in that structure. If you get a case where you see the words substituted parenting being bantered around, make sure you come back to REH. It is exactly the judgment you need, because of course it is a proportionality argument, and it is very difficult for anyone to say it's substituted parenting without first outlining what the support on the ground that could be available would look like, and then going to why that wouldn't be enough. So that was a lesson to learn from that case. In particular, it's the point I make about the support and substituted parenting. The judge had considered the parents' ability to meet the children's needs had not changed, therefore would not do so in future. Didn't properly evaluate the situation, proportionality couldn't stand. Now, that's the case law up to 2023. So this year, where we're up to, that's the guidance. And we've talked about what's typically done in PAMS assessments and in care proceedings as well. What I want to talk to you about is this 26-week drive. And I'm conscious of the time. I'll only have you for another 5 minutes, guys. We see recently, for instance, from the president, that there is this radical, as he calls it, a radical resetting of the culture within the family court to stick to 26 weeks. And one may think, if you're for the guardian or if you're for the local authority, well, no matter what these parents may need, we need to make sure we do this in a timely manner. My advice to you is to be brave, because of course justice must not be sacrificed on the altar of speed. But of course, I think you also have case law that will assist you in this regard. You see, back in I'm just checking I've got this right. It is this one, yeah, it's RES. It was the previous president who turned around and identified, so Mumby identified that whilst, of course, we must do our best to do things in 26 weeks, there are some cases that just don't fall into the category. And one of them, he talked about 4 examples of that. And the one that he identified, or the last one he identified, was cases where the parents' disabilities require recourse to special assessments or measures. Be ready to champion that cause, because whilst there is a drive for 26 weeks, parents with learning difficulties require special measures. They require time to absorb, and they should not be pigeonholed into 26 weeks. That is my view. RES gives you some case law to rely on if you need it. I also think RE-C, the one that is quoted there, is also relevant, because again, RE-C was really relevant. Because what happened in RE-C was this: the Court of Appeal remitted a fact-finding hearing for rehearing in a case where there was a deaf parent, and Lord Justice McFarlane set out the importance of providing BSL interpretation, both in court and in assessments and in pre-hearing discussions. He said that proceedings should not be driven, and this is paragraph 36 of that judgment, by the 26-week timetable, where this is incompatible with an effective and meaningful assessment due to disability. So again, RE-C, RE-S, really useful cases from 2014 that I think can still withstand the test of time now in 2023 if you're being told we need to do this in 26 weeks. My answer is no, not where we have a parent with a learning difficulty or disability. Pause it and do it right. Otherwise you end up right up in the Court of Appeal, and I almost think it's not worth the hassle. So we've talked lots about this, and I hope that assists you all to understand how the courts approach it. But let's talk about this point I keep hammering on about, which is support. I want to talk to you about, I think what I should say is, we all know about support that can come for things like a care order, but there are other ways that support can come, ways that we don't always conventionally think about. And I wanted to talk to you about that, about the ways that support can come for these parents with learning difficulties that we need to be alive to as practitioners and as people who will champion the cause. The first is the obvious one, the Children Act. We know that if the child is subject to a care order, a whole package of support opens up to them. Things as simple as making sure they have regular health assessments, at least once every 6 months in the case of children under 5, at least every 12 months in the case of children age 5 or over. So Children Act, care order, lots of support. We know that the Children Act also means things like Section 17 responsibilities from local authorities to making sure that children in their area have their needs met. We know that if, for instance, the parents will require respite breaks, etc., we have things like Section 20, where children's accommodation could be provided on a temporary basis. So we know that those are all options available that will have to be considered depending on the case. What I think I would also like to flag, though, in addition to that, is a few other areas of law that we sometimes maybe don't always think about. The first is the Care Act 2014, because we may or may not know about Care Act assessments. In essence, the 2014 Act says that if a child, a young carer, or an adult caring for a child, i.e. our parent, is likely to have needs when they turn 18, i.e. a young carer, the local authority must assess them if it considers there is significant benefit to the individual in doing so. This is the adult services limb of making sure that people get proper support. And it's quite useful, I think, when you know that there are going to be issues here for the vulnerable parent you represent or the vulnerable carer to get them support using a Care Act assessment. Because you know that happens. We see these parents all the time, and they're not always 30s, 40s. They can be teenagers themselves who are just coming out of care or who are very vulnerable. The Care Act is a way for them to get further support. We know that sadly learning difficulties can often be hand in hand with learning disabilities, and if so, there are certain disabilities and other mental health acts that can assist to provide support. So the first one I want to flag there is the Chronically Sick and Disabled Persons Act. It was to make provision with respect to the welfare of someone who's chronically sick and disabled, and for people and to provide sort of practical support for them. So that's another avenue. If your client might fall under that, look at the Act, see if you can gather support through that route. It can do things like making sure that they have practical assistance in the home, recreational facilities. It can fund things like holidays for them. It can even assist with providing something as basic as meals for them, which might assist the situation. We also know about the Children Leaving Care Act. I don't seem to have put that on there, but the Children Leaving Care Act, if your client is someone who has been a care leaver themselves, remember that they are entitled to appointment of a personal advisor, duty to keep in touch from the local authority, to give assistance, to have a pathway plan. All of that is part of a package of support that we often overlook. I think we should also be alive to the Autism Act, which was designed specifically to planning for people with autism as they will move from children to adults and actually even into adulthood. So again, useful act to make sure that the needs of adults with autistic spectrum conditions, and that is how they define it, so it's much wider than we think, can receive further support. Then you hear the typical friends and family network, and again I endorse that, family group conferencing, and making sure that we have an idea of the wider support that can be provided. Things, as I say, like nursery, like daycare clubs, like baby groups, those sort of things. Make sure that those are also part and parcel of the package of support. So when we look at it like that, the package can be a lot wider than we perhaps initially thought about. And you must make sure that all these services who might have duties to your clients and or the child are part of the support package that will be outlined before the local authority and or guardian and or other professional says, no, this is substituted parenting. You need to be able to show, no, actually look at it, there's quite a lot that can go in here. That will mean that these parents could parent with support. I think one thing I want to flag as well is just about funding, because we know that when people turn 16, they can claim benefits, or someone can claim benefits for them. And so that's a way to offer financial support. As I say, adult services can fund certain things that can be of assistance. But I want to flag this, which is the NHS Continuing Care, so CHC, can become involved for relevant cases. And It's worth knowing about this because sadly, as I say, some cases with learning difficulties can also factor in with disabilities and other mental and physical health issues. The NHS CHC can offer fully funded care by the NHS, but it's only available to those who meet the criteria of, as they describe it, having a primary health need. The National Framework on NHS Continuing Care defines this care really being there to assist people with disability, accident, or illness. And the package can include health and social care services and sometimes even things like accommodation. So the NHS can provide some funding and support as well, in addition to everything social care can, or it can assist social care in opening certain doors. And that's something you need to be aware of. What have I got? It's 10 past now. I don't want to keep you very long, so I'll beat through this very quickly. When we come to court then, and we've talked about how to assess and the kind of support that can be out there, the final thing I want to touch on is really the court process, because we know that the court process is daunting for everyone. I get daunted by it sometimes, I'm sure you all do. Imagine what it must be like for a parent with learning disability and or difficulty. We know that their Article 6, the right to a fair trial, will be engaged, but there are certain provisions under Family Procedure Rules 3A and 3AA around vulnerable witnesses, around, for instance, capacity practice direction 15B, that is available and open to them to make sure that they get support. And we need to be alive to that. So on the handout, I've given you it in quite a lot of detail. Remember your duties from REA that we discussed when the court said the advocate, the lawyer needs to be flagging certain things and getting assessments done at the case management hearing. Remember that, because that will come into play to offer support. But also remember that if they give evidence, there is a growing body at the moment around the issue of how to cross-examine these vulnerable people. And I would say, having gone on the vulnerable witness training, that in fact, there is a lot to be learned here. I now say that if someone is going to cross-examine my client, they should have had some form of vulnerable witness training. And there is a growing body of judges who agree with this and will question that before setting up the trial or before deciding who is allowed or permitted to cross-examine. I would say be alive to that. Get yourself booked on to vulnerable witness training. Make sure for clients that the people who will cross-examine them, I don't know why I said that, have had appropriate training, because that can make the world of difference for them in terms of how they are able to participate in the process. Remember the importance of intermediary assessments, and it's not just for giving evidence, it can support them throughout the process. I think people sometimes can struggle with when an intermediary is needed, and so I have given you some guidance on the slide on that, because it's not just about like helping them to understand things. It can be far wider than that. It can be far more about the support, just them feeling supported in court, making sure that they follow what multiple people can say in court, not just one person or not just the concept being too hard, but when lots of people from different seats in court, in essence, are speaking to the judge. And make sure that things like rule hearings are not overlooked. And as I say, vulnerable witness training is adhered to. So I've gone through the last part of this quite quickly, but I hope that assists you. Please read it alongside the wider information I've given you in the handout with it, which has it in far more detail. And then just looking at what we covered today, we explored the kinds of limitations that parents with learning difficulties can face. We looked about PAMS assessments, for instance, parenting assess model, the kind of things that can be done and is normally done in care proceedings. We've looked at what the law says about how these parents should be supported and what the process should look for them, not just in terms of assessments, but also in terms of what the courtroom should look like for them. And we've looked at the ways that you as an advocate can challenge matters and what guidance you can rely on. For instance, the practice guidance from 2016, which has been updated in 2021. I hope this has been helpful to you all. I'm sorry that we ran over a little and we're a little bit late. And I'm sorry that I can't really take questions through this medium. But if you have any questions, please do email me. If you need the handout, feel free to message me and I'll send it over to you. And otherwise, thank you for coming. And I hope this seminar has been helpful.